Friends, we move to the second session of the series on international humanitarian law. And in that, we speak today on law of armed conflict. Armed conflict, as the name indicates, is a situation when two countries, the two sides are at war. Well, IHL is the law which governs, which comes into play even in such situations when there is a war. International humanitarian law is that part of IHL which regulates the conduct of armed hostilities. So it is when the two sides are at war, they have taken up arms, and the security forces, the military, are facing each other, engaging them in target. In that scenario, the regulations and the rules which come into play, which the member states of the United Nations, the community of nations, have agreed to abide, it is the law which is known as international humanitarian law, which is also called the law of armed conflict, LOAC, or simply the law of war. Why it is called law of war, which was the name earlier and now it is called law of armed conflict. One of the reasons is that the nature of war as it exists today, in very many cases, there is no formal declaration of war. So the countries usually hesitate or they do not prefer to declare that they are at war, although they may be engaging the other by various means, the weapons available with them, yet they do not make a formal declaration of war, and that is why it is also, IHL is also called the law of armed conflict, in short LOAC. The main underlying purpose of IHL can be seen from two aspects. One, humanitarian, and in that, unnecessary suffering, injuries are to be avoided at all costs and situations. And how do the armed forces use force? How should they function? What they are allowed to do, and where is the red line for them to stop with regard to their functional efficacy? This also is laid down in IHL. The first purpose, which is humanitarian in nature, keeps in mind and is aimed at protecting combatants and non-combatants from unnecessary suffering. While protection to the combatants is from the injurious effects and consequences of war, insofar as non-combatants are concerned, uh, they are to be protected also from collateral damage. Apart from this, IHL humanitarian purpose keeps in mind that those who have been detained and who have come under captivity of the opposing force, their fundamental human rights must be protected and saved. And by the first two methods or the first two limbs, there is an effort for restoration of peace, and unnecessary tension, suffering is stopped, or it is protected from further escalation. Moving on to functional purpose of the IHL, by laying down the rules which are there in the Geneva Conventions and their additional protocols, to which we shall shortly revert, the good order and discipline of the troops is ensured, because it is expected that both the sides or the various sides which are engaged in armed conflict, they all behave in a manner keeping in mind the good order and discipline. And this disciplined manner of fight, combat, is made out in such a way that it is consistent with the national values on which the armies are organized and they function. And thereby, from the aspect of reciprocity, the other side, if one behaves, the other side would also be expected to behave and engage in reciprocal behavior. And this helps in maintaining a good domestic flavor and maintaining international public support. So these, in nutshell, are the functional objectives that are kept in mind. There are four core principles of IHL. They need military necessity, unnecessary suffering, discrimination or principle of distinction, and proportionality. Military necessity indicates and highlights that the force used, the lethal force used, or the behavior shown should not exceed what is barely necessary or what is expected by military necessity. And therefore, use of force particularly and the behavior with the adversary should not go beyond what is expected in military necessity doctrine. Flows from the first principle is the notion of unnecessary suffering, which is to be avoided. Unnecessary suffering is from the aspect of those who have been targeted and also those who are under detention. And extending beyond, it also covers those who are non-combatants. So, with regard to each of these categories, unnecessary suffering, what is not required, is to be avoided, must not take place. There is always a discrimination between a military target and a civilian, which is the non-military target. So, therefore, for example, while resorting to artillery fire or armored fire or air attacks, the schools, the railway lines, which etc., which are not connected to the military efforts or the war efforts, are not to be protected, they are to be saved, and they are not to be attacked. Use of force, lastly, should keep in mind and should be confined to proportionality. A disproportional resort to attack is to be avoided, and therefore proportionality. For example, if there is a soldier uh, who's indulging in sniper fire on our side, so against a soldier you cannot bring an armored column attack. So therefore the proportionality is to be borne in mind. The protection under the IHL extends to, and these are the four distinct Geneva Conventions. Geneva Convention, and these are all of 1949 vintage. The first convention addresses sick and wounded during war. Those who are not able to, because of their medical and physical condition, fight and they need full protection. Second convention is directed at those who are in naval combat or shipwrecked at sea. Geneva Convention number 3 extends to prisoners of war and those who have been taken in captivity. And the fourth convention lastly relates to civilians who may be in combat zone or in proximity of a theater of war. They need full protection and due protection. Now these four broadly are the Geneva Conventions of 1949, which were drafted and agreed upon came into force after the conclusion of a Second World War. There is also a law of Hague, law of Geneva and law of Hague. Now, law of Hague regulate methods and means of war. Now, this talks about the new weapons or how much force can be used, what can be targeted, what is not to be targeted, what precautions are to be taken. All these are included in law of Hague. And then, apart from Geneva Conventions of 1949, 1, 2, 3, and 4, which we just saw in a previous slide, there are 3 additional protocols. In short, they are known as AP1, AP2, and AP3. AP1 pertains to international armed conflict situations. AP2 relates to the use of force or armed conflicts which are of a non-international nature. Now, these may take place within the territory of one country or between two states, but the confrontation or the armed conflict may remain of a non-international nature. AP3 relates to the distinctive emblem, the protection that it affords, the legality of its use, who can use it, and this is the protective emblem, say, which is used, which is worn by the medical personnel or the religious personnel in combat zone. This was indicated that AP1 of 77 vintage relates to victims of international armed conflict. The next is protection of victims of non-international armed conflict, and AP3 distinctive emblem. It is important that for a clear understanding of Geneva Conventions, which form the main component of IHL, having regard to the technical nature, it is for easy for easy understanding that the book, which is there, Law of Armed Conflict, Application and Practice, can be read, which explains the various provisions of Geneva Conventions and Additional Protocol, rules of customary international humanitarian law, by giving examples in a conflict situation where there are two countries at war and there are neutral or other neighbors who have not joined the battle. How does LOAC apply in these situations? The book is an attempt to make this easier to understand. There are certain other treaties which were adopted after 1949 when the Geneva Conventions came into being, and these further protect and save those aspects which need to be protected during armed conflict situations. For example, cultural property and heritage buildings and sites, for which there is 1954 Cultural Property Convention. Then on use of biological weapons and biological armament of 1972. Then regarding certain conventional weapons which cause unnecessary suffering like cluster bombs and ammunition, 1980 convention. Then chemical weapons, 1993 came into existence and it was agreed upon. Then there is an Ottawa Treaty and Rome Statute. Now these two pertain to International Criminal Court, which came into existence, and which is the Rome Statute and the Ottawa Treaty, was pertaining to ban on use of anti-personnel landmines. because these landmines cannot differentiate between own troops or those of the opposite side. They cause totally indiscriminate loss, injuries. So this came into being, and then there is the Refugee Convention of 1951, which was followed by a protocol that was more elaborate in 67. And there are certain aspects, despite these treaties and conventions, which continue to engage further attention. Just to indicate to you, there is the element that need to be saved, that need to be protected, is the category of children and women. Then environment. Now, environmental damage and degradation during war and because of war efforts needs to be protected. And the third aspect on which there is a need for further dialogue, discussion, exchange of views is the one concerning global terror. And of course, there are nuclear weapons, which is not included or shown here. In IHL, very frequently one would hear the term hostile combat, and a person is said to be hostile combat. This term is used for those who may be in the power of an adverse party, meaning, for example, a prisoner of war who is held captive by the other side, or someone who clearly expresses an intention to surrender. For example, shows a white flag. You see the image on the slide in front of you. These soldiers, group of soldiers, are showing a white flag, which means that they do not wish to fight. They are wanting to surrender and may be engaged in a dialogue. Or those who have been rendered unconscious or otherwise they are not in a capacity by wounds or sickness, and they cannot defend themselves. They need to be protected. However, all these three category of persons would lose their status of protection or the label of hostile combat if they engage in acts of war or they oppose the enemy, their previous enemy. So in those situations, their protection would come to a halt. Conversely, the lawful combatants are those persons belonging to the armed forces of the parties to a combat. They can carry out attack. In turn, they may be targeted and they may be attacked. And when they are part of the regular military, they bear no criminal responsibility when they target the opposite side. You cannot frame a charge for them against the penal code. They can be tried and punished for breaches of war. So if they are soldiers who are part of the regular army or militia or the defense forces, and if they overlook the laws of war or international humanitarian law provisions, they can be tried and punished if found guilty, and they have the protection that in case they are captured, then they are to be treated humanely and they are entitled to prisoner of war status. That is their privilege. Just to illustrate to you who all are non-combatants, for example, military medical personnel, the doctors, paramedical staff who's there to treat sick and wounded, or chaplains or the religious personnel. In Indian Army, we have these Sarvadharma sthals, where at one place there is a temple, there is a mosque, there is a church, or Gurudwara. Now, these are manned by religious personnel. They are also non-combatants, or say the cadets of training academy, or the workers in ordnance factories and the like. They are all non-combatants and they need to be protected. Yet another relevant aspect in IHL is command responsibility, which in brief or in short entails that a commander is responsible for the act of his subordinates. Commanders are responsible for war crimes that may be committed by their subordinates in the situation where they ordered such acts, or they knew of the act and did nothing to prevent, to bring an halt to such acts which are in the nature of a war crime, or it was expected that having been in the position of command, they ought to have known what their subordinates were doing. War crime is a word, a term that you would frequently hear during the course of IHL. This relates to grave breaches of the Geneva Conventions and other serious violations of laws and customs applicable in international armed conflicts, which are or which may not even be of an international character, and the serious violations of Article 3, which are common to all the four Geneva Conventions. And what is this Article 3? We shall see in the next slide. Article 3 says, and the text says, following acts are and shall remain prohibited at any time and place. Violation to life and person, in particular murder of all kinds, mutilation, cruel treatment, and torture. So even if there is a person from the opposite side, well, he cannot be murdered, or if found in captivity, taken in captivity, cannot be subjected to cruel treatment, torture, or mutilation. Taking of hostages with a view to compel opposing side to listen to you, to abide by your dictate, well, taking of hostages is prohibited. Then outrages upon personal dignity. This is applicable, say, especially in the case of females. Humiliation and degrading treatment is prohibited under all circumstances. And lastly, passing of sentences or carrying out murders, death penalty, without previous judgment pronounced by a regularly constituted court, which affords all the judicial guarantees which are there in any civilized nation if such sentences are given, or if executions are ordered, carried out. Well, these are prohibited at all times. Having regard to the foregone, it should become apparent that soldiers, it is there is a need, it is their duty that they should be disseminated and made aware of law of armed conflict. It would prevent them from being in a position where they are responsible or they are singled out for internationally wrongful acts. And for this purpose, the states, member states of the United Nations, community of nations, they need to ensure that their soldiers comply in letter and spirit with the law of armed conflict during a conflict situation. And for this, regular training, rehearsals, dissemination activity is needed to be carried out prior to war also. In conclusion, it is pointed out that increasing role of India in the strategic and security domain makes it imperative that India and its troops, its commanders, must adhere to the law of armed conflict in different situations of engagement, which may relate to, say, attack, defense, advance to contact, or internal security situations, or in peace engagements of the United Nations. Whatever may be the situations of engagement, the law of war is to be understood and complied. Thank you.